Hello friends, welcome back to my channel. Today I have come up with a video where I would like to highlight an important topic. In the previous videos of mine, I have seen that many people are commenting that today's women, the Indian women, are becoming extortionist, and in terms they are responsible for the downfall of the Indian men. So this is what I have got in various comments. So I would like to address these issues. So let us now, in order to address those issues, we'll have to come up to a point where we'll have to understand whether the Indian law is equal for both men as well as women. So what laws or what benefits are being given to a man and what benefits are given to a woman. So as we know that India is a vast country, there are many other religions and there are various issues in our country, but I would like to specifically highlight the Hindu men and Hindu women and their right of inheritance. So with regard to this particular topic, we'll dive deep into the Hindu Succession Act 1956 as well as the Hindu Succession Amendment Act 2005. These two particular things will try to make us clear regarding whether the rights are given equally to both men as well as women in the terms of inheritance of property. So as we know now, initially first I'll go into what the rights of women are, what is there in the law, and then we'll come up to the laws regarding the men, and then we'll come up to what the Honorable Supreme Court has said. So let us start with this, and we'll have to first initially get into that what was there in the pre-Succession Act era. So here we know that the Indian law has been governed by both the Mitakshara as well as the Dayabhaga law of inheritance. So initially the Mitakshara school, the woman was not granted as a coparcener, and on the other hand the Dayabhaga school allowed the widow to inherit the property of her late husband. So thus the Dayabhaga school offered a great right to women than the Mitakshara law. So but even under the Dayabhaga law, if a widow woman without a son, if a woman died without a son, her property would be passed on her nearest male heir irrespective of whether she had daughters. So the Hindu Succession Act was enacted in 1956 to bring about the uniformity in inheritance law and confers greater rights on women. So Hindu Succession Act, Hindu Succession Amendment Act 2005, when it came into place, it sought to an amendment of the provisions. Those were contrary to the woman's right to inherit property. Here are some important changes. I would like to highlight that the Hindu Succession Amendment Act, it changed the discriminatory provisions. Initially in section 23, it was that it discussed that the inheritance of a dwelling house, if a Hindu died without leaving a will and was survived by both a male and a female heir, in this case a female heir would have no right to seek partition of the dwelling house unless the male heirs wanted so. So then initially she was under the coverage of a male heir. She would have been under the rescue of a male heir, and section 30, it had originally said that any Hindu may dispose by will or other testamentary disposition any property which is capable of being so disposed of by him. So only a man would have been able to be to dispose his own property by way of making a will, but a woman did not have that right. But after the Hindu Succession Amendment Act 2005, it reads that any Hindu may dispose of by will or other testamentary disposition any property which is capable of being so disposed by him or by her. So here the woman has been emphasized, so specifically giving her right to dispose of her property by way of will. So this is how the women are slowly being empowered. So you are very much aware of the fact that the Indian women have got their rights very lately in the year 2005 regarding the inheritance of property. So here the coparcener rights were they given to the woman. The coparcener, the concept of coparcenery is at the heart of section 6. Now coparcenery refers to descendants who can legally claim the property of a Hindu ancestor after he or she dies. A woman would not claim inheritance as a coparcener under the provisions of the original act. So now after the Hindu Succession Amendment Act came into, and it modified this discriminatory issue, and as per the current version of section 6, the daughter of a coparcener shall by birth become a coparcener in the same manner as a son, and she will also have the same right in the property as she would have had been a son, and to subject to the same liabilities as that of a son. It is not that the rights are only given to her, the responsibility of the liabilities are also there as equal to that of a son. It further states that any reference to Hindu Mitakshara coparcenery shall be deemed to include a reference to a daughter of a coparcener. So here now the absolute ownership of the property is being given to her, and lately we can see that the Hindu Succession Act, the rights of the property of a mother in India is being guided under the class 1 of the legal heirs, and so her property rights are governed by the relevant sections of the Hindu Succession Act, section 6, 8, 9, 10, 11, 14, 15 and 16. So the rights of the property of the daughter is also equally given there under the Hindu Succession Act, and the Honorable Supreme Court in the year 2018 via judgment named Vinita Sharma versus Rakesh Sharma and others is also very much important to this in this perspective. It said that the daughters enjoy equal coparcenary status with sons irrespective of when they were born or if their father was alive on 9 September 2005 when the Hindu Succession Amendment Act 2005 came into force. Now the married daughter's right in father's property, here the marriage of a daughter has no relevance for inheriting property. So a daughter, she enjoys the same coparcenary rights as a son. Moreover, she is also a class 1 heir. So relevant sections of the Hindu Succession Act will also be applicable in this case. So the property of a married woman in India where a widow is a class 1 heir under the Hindu Succession Act, if a male Hindu dies without leaving a will, the property succession is governed by the provision of section 8, 10, 9 and 10. And rule 1 of section 10 says that if a Hindu male dies without a will, then the widow or the widows, if there is more than one, shall take one share. Apart from this, all the rights shall occur to a daughter are also available to a married woman. So the Hindu Succession Amendment Act 2005 significantly increased the woman's likelihood of inheriting property. In certain cases, it also leads to an increased age of marriage for women. Moreover, even if a woman has not inherited property, the fact that she is entitled by law to do so can significantly increase her bargaining power. In the Indian context, this can also lead to a greater voice in terms of marital affairs. Now coming back to the laws that are being given to a man, here under the Hindu Succession Act 1956, here under section 8, the general rules of succession for males are being given. It applies to the property of a male Hindu dying intestate, means if he doesn't have made any will or something else. So it specifies that the order of succession will go to class 1 heirs, then class 2 and then the agnates and then the cognates. In this class 1 heirs inherit the class 1 heirs inherit the property simultaneously and to exclusion of other heirs. So section 10, distribution of property among the class 1 heirs. Their section specifies how property is divided among class 1 heirs. It states that equal distribution of property must be among the son, the daughter, the widow and the mother. So the children of the deceased parents gets their parents' share out of the ancestral property. So the rules of this is stated, of these provisions are being stated that the intestate widows, or if there are more widows than one, all the widows in-laws together shall take one share. Rule 2 says that the surviving son and the daughters and the mother of the intestate shall take one share each. So the heirs in the branch of each predeceased son or each predeceased daughter of the intestate shall take between them one share, and the distribution of the share referred to in Rule 3 among their heirs in the branch of the predeceased son shall be so made that his widow or widows together and the surviving son and the daughters get equal proportion, and the branch of his predeceased son gets the same proportion. Among the heirs in the branch of the predeceased daughter shall be so made that the surviving sons and the daughters get equal proportion. Here I would like to make a reference to the case of another Supreme Court, where it has been said that the illegitimate children have inheritance right to their father's separate property and under Section 8, and however they cannot claim rights in ancestral property. The judgment expands to the interpretation of son in Section 8 to include illegitimate son for certain inheritance purposes. So here the general rule for succession have significantly changed the landscape of the property inheritance for Hindu male in India, promoting gender equality and ensuring a more balanced distribution of assets among heirs. The law aims to provide a more equitable distribution of property among heirs, moving away from the traditional patriarchy system. In the absence of a will, the property is distributed according to this statutory rule. So now I would like to come upon a particular judgment, recent judgment given by the Honorable Supreme Court, where it has been very much discussed that it has come up to a point that whether there is a gender inequality under the legislations, which actually there is the property is not being properly disposed of or being distributed among the two genders. So the Honorable Supreme Court asserting that the inheritance norms prioritizes a woman's husband's family, not gender inequality, urging there to be legislative changes only. And this Honorable Supreme Court asserted that the established norm of Hindu society should not be changed solely for financial gain, as it observed that the Hindu Succession Act of 1956, which prioritizes a woman's husband family over her parents in inheritance matter if she dies intestate without a will, is not an issue of gender inequality. The court further said that the Parliament has crafted a scientific and a logical framework for inheritance, and any changes should come from the legislative body if deemed necessary. So it is a clear that there is no gender inequality as per the Honorable Supreme Court, and it says that about the parents asking for the properties of the daughter who is no more, but tells that about the woman who leaves her parental home, goes to her matrimonial home where she has a right to be maintained under the Hindu Adoption and Maintenance Act. How can this be a gender justice? So it cannot be. So we are not talking about a woman. The Honorable Supreme Court has said that we are not talking about a woman's right, but the rights of a deceased woman's parents or someone else's over her property. So the Honorable Supreme Court in this has also very much specifically mentioned that the woman gets a new gotra, a new family, and all rights and titles of her husband's property. So here you are the Honorable Court has also further stated that remarks that this particular inheritance law has been carefully drafted, and if the properties have come from her parents, they will go back to it. And like if a woman has inherited a property or she has self acquired a property, then it is her sole exclusive property, and if she dies intestate, then the property will go as per the schedule has been defined, where it is goes to her son, daughter, then her husband. And then the other points of lineages are also there, which I have specifically mentioned in a few times like in my first part of this video. So that the properties have come from our parents, then it will go back to them, and if the properties have come from the in-laws side, it will go back to the in-laws. And this is what the Honorable Supreme Court has said, and the observations made by the top court came after the hearing of a set of of challenges to the scheme of 1956 Act, which creates two different sets of succession in case of men and women dying intestate. Under the law, when a Hindu man dies, the property left behind him are to be distributed equally among his wife, children and his mother. If there is no successor living on that day, the property of a Hindu man goes to his father. But however, under section 15 and 16 of the Act, when a Hindu woman dies intestate, her property includes self-acquired assets which shall be inherited by her children and husband. If the woman has no living husband or children, their heirs of the husband shall inherit the property. Only in the event that the woman's husband has no heirs shall the property be inherited by the woman's parents. Furthermore, the property of a woman goes back to a source from whom she inherited the property, as such the father, husband and the father-in-law. Like if a woman has inherited a property from her husband, then it goes back to, if she dies intestate and there is no any other legal heirs of the husband, it goes to the legal heirs of the husband. If she doesn't have a children or her husband is not alive, it goes back to the in-laws. And if she has inherited the property from her father or mother, then it goes back to them. And likewise, this is how there is a differentiation between the distribution of property among the men and women. So here the property for a man goes to the children and as well as to the mother and the wife, but in case of a woman it goes back to the in-laws are being given a privilege, and if the property comes from the in-law side, so they will be inheriting the property. So there is a differentiation in this particular fact. As we know that the marriage, so here Hindu law, it is very much deeply rooted into the cultural thing. So we are very much aware of the Hindu law. So this is how things are going on. So I do not would like to say whether there is an inequality or an equality. It is upon you to judge the particular law, that whether it is making any differentiation in your own personal life. So this is with this I would like to end the video, and hope you would also comment in the comment section and give your valuable views there. Thank you very much.